Alan Clancy. To these indictments, the defendant at the bar pleads not guilty and for trial places herself upon the country. Which country you are. You were sworn to try the issues. If she is guilty, you shall say so. If she is not guilty, you shall say so and no more. Members of the jury, hearken to your evidence.
All right, thank you, Madam Clerk. Now, members of the jury, and really, this is the first time I can technically call you members of the jury, because you don't become the jury in this case until you take that great oath that was just given. And that's an oath that has been given to jurors for hundreds of years here in the Commonwealth of Massachusetts, where you've sworn to well and truly try this case. We have confidence that you're going to be able to do that. And so what I'm going to do at this point is I'm going to give what we call a pre-charge. All right? And all that really is kind of an orientation to you to the procedures that we're going to have as the case goes forward, and kind of go over some of the terminology that you might hear, to give you a little bit of an idea what some of the principles of the law are that you'll have to apply to the facts as you find them. So as we go through this, I just kind of, again, I'm going to explain it, and then after that, we're then going to go right into the opening statements of counsel. All right, so first, as you know, this is a criminal case, and the defendant was charged by the way of an indictment on 3 counts. All right, now you have to understand that an indictment is not itself any evidence of the defendant's guilt whatsoever. It's merely the formal way of accusing a person of a crime in order to bring her here to this courtroom for trial. You are not to draw any inference of guilt from the indictments or from the fact that she was indicted and formally charged. Now, in every criminal case, the defendant is presumed to be innocent unless and until she's proven guilty beyond a reasonable doubt. The law requires the Commonwealth, that is the prosecution, to prove that the defendant is guilty beyond a reasonable doubt. The law does not require the defendant to prove her innocence or to produce any evidence. At the end of this trial, you must find the defendant not guilty unless the Commonwealth has proved to you beyond a reasonable doubt that the defendant has committed each or any of the offenses with which she's charged. Now, I'll more formally instruct you on what reasonable doubt is later. But a charge is proved beyond a reasonable doubt if after you've compared and considered all the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. It's going to be your duty, the duty of the jury, to determine whether the Commonwealth has proved its case against the defendant beyond a reasonable doubt, and that decision has to be based only on the evidence and